reflect on that and build that into
Yes,
our argument.
we'll
We
bring it in.
fully understand what my lord is saying. Fully understand.
Can I say one thing?
Not only one request I would
but
make.
people who are not in the part of the dialectic. Because we've all gone and spoken on in seminars, and there are people who believe in the absence of heteronormative institution of marriage. And when one goes out and meets 99% of the people who come up to you, they all say only one thing, that they want to get married.
Yes.
Because the consensus within the community, no matter how many people may say that it is a concept that they otherwise reject, is that they wish to have marriage.
Yes.
Because this gives meaning, purpose, identity to the people who are seeking to get married. Because it is, and my learned friend will agree with me. So it's not correct to say
Yes.
that there will be people who will be out of the bound of marriage, who don't want marriage, but they are happy with something else. I, Millets, personally, and I'm sure Ms. Guruswamy and Ms. Grover as well, in all the multiple meetings we've had,
Yes.
we hold some academic discussions of
Yes.
people who say, no, it's a heteronormative institution, it's not necessary. The vast majority of the young people I have spoken
Yes. Yes.
have all said, we want to get married. The parents of those young people have said, we want to get married. Because we say we want to get married. Why should we be second-class citizens? Because there was a time we were criminals, then we became third-class citizens. Now they're saying be second-class citizens, then be content. That is not what the Constitution promised.
Yes.
So that's the third category. But I'm not belittling your lordship's first or possibly second category. Please don't misunderstand that. All of us here, but we are all imploring your lordships to recognize a third category,
Yes.
incapable of partial, minimal resolution by the Solicitor General.
Just-
Incapable. But the first or the second, yes, we'll fully cooperate.
And one exercise we also undertake.
My lord,
And we
just-
keep
but I
Justice
just-
Bhatt's
Yes.
that point in mind, that whether we can give up something, not give up that part, I
And
understand.
ultimately,
No, in the sense, that it can be tailored. No, for us, tailored.
My lord,
Can I
but
suggest also,
just
we amongst ourselves, all the petitioners are sitting down and we are trying to make some kind of a draft of what is it that we can hope to achieve. So there's a consensus in ourselves. We understand we can't get everything, because we will put forward some idea of what is it that we hope that this court can give
that's
us.
exactly why we thought that some
Well,
sort of
that
meeting of
that's
some
our
exchange of
concept.
ideas
My
between
lord,
all of you would be helpful.
Consensus is amongst us already that at least Section 4 recognition of marriage has to be given. What rights follow from that, when, how, those modalities.
Yes.
So that is
Are
legislative. No, therefore, my lord, I would request.
May I just say this, my Lord Justice Bhatt? When I speak at different events around this country, I make it a point to speak in small towns India. And I make it a point, and young people in our country want marriage. I don't say this as an elite lawyer. I say this having met these young people. Do not let them experience what we have experienced. Every study indicates that in countries where
Then
there's
let us
marriage,
conclude on the marriage.
Dr. Guruswamy, there's a problem with this line of argument.
no.
I'll tell you why. We understand the feelings out of which this argument comes. But at a constitutional problem, at the constitutional level, there's a serious problem. If we go by what young people feel as a constitutional court, then we would be subject to volumes and tomes of data on what other people feel. Now, therefore, the great salutary safeguard of constitutional adjudication is that the court has to go by what the Constitution mandates.
Correct.
And therefore, we don't go by
Yes.
either popular morality or a segmental morality. We decide what the Constitution says.
But this is
Because the moment you say that this is what young people feel, I'm sure there'll be people on the other side who are willing to throw tomes of material at us on what the country feels.
it's my only.
Let's not get into it at all.
My Lord, this
Therefore, what we were suggesting was this. We get your point that you seek a right to marry. You are also conscious of the fact that a mere declaration of a right to marry is not adequate in itself unless it is implemented by a statutory provision which recognizes, regulates, confers entitlements on those who are married. Therefore, you are conscious of the fact that the implementation of the right, the achievement of progress on the ground depends on whether there is a statutory framework for implementing that right. And therefore, you say located in Section 4. We'll consider that argument. But as we said, suppose we were to come to the conclusion that this argument is not as simple as it appears to be, that there are too many interlinkages with other statutes, including personal law, which we would be treading upon, and perhaps which would lie outside the domain of judicial review. Then what? Then our concern is that, look, everything has to be something which you achieve in incremental steps. This is a social institution. That social institution is also evolving over a period of time. But the court can ensure by acting as a facilitator that real progress is achieved today in terms of a wider societal acceptance of the right to cohabit together. Whether we go as far as to recognize the right to marry for couples who are not heterosexual couples is a separate matter. We'll be dealing with that. We are not shutting the argument to you. That's why we are hearing this side. But even assuming that we don't, we do, that's the end of the matter. But if we don't want you to be in a situation, or the movement to be in a situation where there's nothing else then available in hand, that this matter then goes. That's not the way we are couching this, this dialogue.
See, if you've seen the history, and in this side, you're all acutely aware of the history, you know better. You've seen the ups and downs of that for the last half century, and where it went to, what kind of legislation came, not positive, mostly negative, and how finally you got the judgment that the US Supreme Court gave. Now, you are circumventing all that. Of course, there is a lot of, let's say, feeling in this, a lot of felt, experiences in those. Nobody is discounting that. But if you do gain something out of this, that's a big, big positive. Because, I mean, there are so many processes outside of what we can speak in this country and in society generally, that these gains are also not to be belittled. Now, if you are getting